Hey viewers, welcome. Today we have another chance to spend some of our busy time on matters around the law and what is the matter with the law. As I promised, and I will not let you down, I like conversations around the law that is anchored on research and studies that have been put out there by law scholars, professors in law, and those who are advanced in the thinking around the African jurisprudence. Today, however, I would like to speak about the African customary law and human rights. This reminds me of an article written by Lawrence Juma, law lecturer at the Faculty of Law of the National University of Lesotho. Lawrence Juma entitled his work and research on the following title, quote, "From Repugnancy to the Bill of Rights, the African Customary Law and Human Rights in Lesotho and South Africa." I love reading this article many times. The author seeks to look at the African law and the Western law by applying the criteria the colonizers used and the criteria human rights is using today to interpret and understand the African law. Thank you for this publication, as well as very important contribution to the ongoing conversation around the future of the African customary law and human rights in Africa. The contest between the African law and the Western law in the pluri-social legal cultural societies and the subject of cultures as they present themselves is a demonstration of a clash of cultures in a non-social legal field. By saying all this is about the question of the unknown African customary law and how this social legal field has not been properly known or properly acknowledged by many people even today. Many people relate this failure to the colonization process and the failure for the African states to embark on African-based or competent-based legal education. In this case, Lawrence Juma is looking at the concept of repugnancy and the new repugnancy that may be presented by the human rights advocates. In this case, Lawrence Juma stands out to distinguish between the old repugnancy as a concept by the colonizer and the new repugnancy as a concept by the human rights and their colonies. In this case, we look at the question of the colonizer. The colonizer colonized the colonized. And in that case, for the colonizer to succeed, the colonizer had to impose his laws upon the subjects. Those are the colonized. That one went successfully during the period of colonization, but the British gave the colonization a unique approach. The approach of divide and rule, the approach of rule by proxies, enabled the Africans in their communities and societies to continue adhering to their African legal systems. And in those legal regimes, the Africans managed to deal with their social issues, the issues regarding the stability of the society, social order, social justice, values and principles, and setting standards for themselves. And that is why we can claim that there is continuity among the African people, simply because of adhering to certain standards and values that are entrenched in the African Customary Law. And it is in this manner we can have audacity to address ourselves to the African jurisprudence and its development today. Whenever we say something about African customary law, some people feel it is better not to use it. Especially in Kenya, the use of the African customary law is getting or fading away very rapidly from the words and vocabulary used by many lawyers. Before we get to the reasons why people are switching away from the use of the African customary law, in Kenya there is preference of customary law, or rather traditional law, or rather dispute resolution or mechanisms, or rather alternative dispute resolution in terms of alternative justice system, in terms of mediation, reconciliation, arbitration, and traditional dispute resolution mechanisms. But the African customary law is missing. When the Constitution of Kenya under Article 159 addresses itself to repugnancy and morality, it is referring to the customary law, but not the African customary law. These are all signs of lack of the knowledge when it comes to the social legal field, and the Africanness of our laws is missing rapidly. It is fading away. This is the reason for which I came up with this publication, which I invite you viewers to at least seek to get a copy from Law Africa, based and headquartered in Nairobi, but you can be supplied wherever you are in any part of the world. It is good because it gives us a start with the conversation around the African customary law, as well as the conversation of how to develop the African jurisprudence. In appreciation, I acknowledge the international community and the organizations that after their meeting in Geneva, in Switzerland, came up with a resolution to establish the African Law Library in Rabat, Morocco, whose mandate is to continue the codification of the African law. We can see the direction the African jurisprudence is taking, and there is a lot of optimism, and I do believe personally that the way to go and the future of the African customary law lies in the hands of the international community. It lies in the hands of other countries that have got interest in the African people, and they develop relationship with the African people due to trading, due to shared values and virtues. And in that case, we find the United States of America, European countries, the United Kingdom, the People's Republic of China, as well as some couple of Arabic countries, and as well as Israel. The development and the interest in the African customary law is more than ever before very vigorant. I want to thank South Africa and other South African countries, Zimbabwe, Namibia, Botswana, as well as Chwani and of course Mozambique, Malawi, for having a clear passion. I'm very much appalled by what is happening in Ethiopia. I'm also appalled by what's happening in the DRC and many other African countries such as Mali, Ivory Coast, and also in the Republic of Uganda. It is a dramatic failure of the African leadership to give recognition to the African Customary Law and its jurisprudence, its institutions, and bring a good and comprehensive conversation around the African Customary Law without falling into the pitfalls of the colonizers, that is the repugnancy. Repugnancy, whether the old or whether it is new, should not be upheld as a canon to judge the African legal cultures or to look at legal practices by the people as immoral or as against natural justice or against any moral standard set up by the Western civilization. That would again amount to cultural discrimination and may not be so helpful when it comes to our understanding of justice and also the judicial systems and practices within our countries. It is from this perspective we can deal with such problems as impunity, corruption, or maybe also marriages based on economic interest or marriages for convenience, in which when a man dies, so many women shall emerge from nowhere with children, no children, claiming the share of the wealth. This is lack of values and a system that has entirely collapsed. Marriages that have lost their meaning, families that are very fragile and threatened, and the future of the entire African society at the mercy of the international community vis-a-vis the human rights advocates and propagators. We need to look at the cultural relativism and the theory of relativity. The locus and the point of view may differ, but the principles remain ever the same. Thank you for watching. Peter here, University of Nairobi School of Law, Kisumu campus, and I expect again to see you in the next conversation. We are here to share our thoughts and mind about issues that affect us today.